Welcome everyone to this session, session two. Our speakers are Ewan Smith and Jane Rooney. So Jane Rooney is an associate professor in international law at Durham Law School. She researches on the intersection between human rights, public law and international law. She has published on reform of abortion law in Northern Ireland in leading journals including the Modern Law Review and Northern Ireland Legal Quarterly. She's writing a book for Bristol University Press called Feminist Revolt and the Constitution, Abortion Activism on the Island of Ireland, where she examines the extent to which the constitutional arrangements in the north and south of Ireland facilitated a feminist constitutionalism in abortion reform. Her paper today argues that parity of esteem should exist for feminist constitutionalism vis-à-vis other liberal and critical constitutionalist thought, using the case study of abortion reform in Northern Ireland. However, feminist constitutionalism is mostly excluded from these discourses. Ewan Smith is Associate Professor of Public Law at UCL Laws. Prior to that, he was a Fellow of Christ Church, Oxford, the Shaw Foundation Junior Research Fellow at Jesus College, Oxford, and an Early Career Fellow at Oxford's Bonavero Institute of Human Rights. Ewan read law at Oxford and Harvard Law School. In 2023, he was a Hauser Fellow at New York University Law School, and in 2024, he was a visiting professor at the Faculty of Law at the University of Bologna. He has previously worked at Peking and Tsinghua universities in China and at the National University of Singapore. Between 2005 and 2015, he worked for the UK Foreign Office. And Ewan will be talking about parity of esteem as an expressive constitutional principle. It requires the government to valorise both the wish to stay within the UK and the wish to leave the UK. He'll define the principle, addressing its nature and its limited justiciability. He'll then sketch the content of the principle, ruling out some lavish claims. He'll then consider some of the problems parity of esteem presents, understood in this way as an expressive principle.
I was just talking to Wendy Louise there, and it can be dangerous to come from Glasgow. It's dangerous for all sorts of reasons, including heart disease, football, and the fact that people don't understand you on the telephone. But there's a special sort of danger connected with the subject matter that we're here to talk about. I don't think it's appropriate to use the way in which the communities are structured in Scotland as a frame of reference to understand the way they work in Northern Ireland. Chris has already spoken about the others. I'm mindful of the fact that I'm an other. And so far as parts of this talk are going to be about community, I'm here to listen rather than to talk. There's a second problem, though. I'm speaking about parity of esteem as a constitutional principle after the keynote. I thought I'd made it perfectly clear to Tom that I had to speak up the playbill from Professor McCrudden. But I'm from Glasgow and I was speaking on the telephone and clearly didn't understand me. And so that presents a problem for me in that I don't want poorly to recapitulate what Chris has already said. But at the same time, I also have to respond to an argument that Chris made because it covers the same territory that I wish to talk about in my presentation. In particular, I mean, if I've understood the presentation correctly this morning, Chris has argued that it's difficult to frame to frame parity of esteem as a constitutional principle, and it's probably not justiciable in any event. Now, there are aspects of this that I quite simply accept as fact. I know that skeleton arguments across Northern Ireland are not placing this at bullet point 1. I don't mean to contest that. I think the best I can say is maybe they should. Maybe there's something in this that's different to the way that we talked about it before, and maybe that would be valuable. And my talk is going to start by looking at the nature of constitutional principles and how this might work. I then want to talk about what the content and meaning of this constitutional principle is. And then I'm going to look at some problems. How should it work? So first of all, what's a constitutional principle? Well, I largely agree with Chris. It's an idea that explains and organises legal rules. It's not itself a legal rule. I'm not claiming that there is a legal rule that says you have to have parity of esteem. I note that constitutional principles are often derived from international law, and that it's common for the law, both in Northern Ireland and elsewhere in the UK, to draw on international treaties as a source of constitutional principles, which is to say, as a source of ideas that organise other legal rules. Take two examples. Alistair's reference, the Court of Appeal says in construing Section 1 of the Northern Ireland Act that the interpretive context, and I quote, is provided by the 1998 agreement, although not itself part of domestic law. The court then sets out the principle of parity of esteem in Alistair. The same court makes the same point, again with explicit reference to parity of esteem in McCord's reference. So what I'm saying is that this is an idea that can organize other legal rules. And in particular, I think it's what I'm going to describe as an expressive idea. It's about the way in which the state makes its values clear. But it can also sound through specific legal rules which are legislated in domestic law. An example would be Section 76, which we mentioned in the first panel, and I'll come back to that later in my presentation. Is this justiciable? Well, it depends what you mean by justiciable, and it depends on what the principle means. So I don't fully agree that parity of esteem is as broad as some of the speakers have drawn it up until now. I think so far as it's a constitutional principle, it cuts quite sharply, and that's going to be key. But its justiciability depends, first of all, on what it is, and second of all, on what it means. You know, what kind of principle is it? Well, it's a way you organize other rules, but also what's its content? The basic statement of justiciability in UK constitutional law is a case called Shargill and Kyra from about 7-8 years ago, where Lord Neuberger, Lord Hodge, and Lord Sumption for the Supreme Court give two definitions. They say, first of all, a rule needs to have a domestic foothold. Doesn't mean it has to not be based in international law, just has to have a domestic foothold. Second of all, there can't be an existing rule of constitutional law, which means that we can't apply this rule. Now, depending on how broadly we draw parity of esteem, there could obviously be reasons why it wouldn't be justiciable. So looking at the language rights case, or looking at a case like McLean, there are clear reasons to do with the nature of Parliament, or to do with the nature of target duties, that mean we can say that application of this rule would be non-justiciable. But we don't abstract from that to say that the whole principle falls down. In particular, I don't think it's fair to say that the political relationship between communities in Northern Ireland is basically subject to the political process rather than to judicial processes. There is nothing in Northern Ireland that is not constitutionalised. I think, if anything, this is more likely to be justiciable because of the way in which it's framed in this place than it would be in respect of another part of the UK. But of course, it depends on what we think it says. So the way in which we frame this principle, its breadth, is one of the things that's likely to persuade us that it's either justiciable or non-justiciable. The example that Chris used was parliamentary sovereignty, clearly a constitutional principle, though a rather wider one than parity of esteem. That could be a legal rule that says what the King and Parliament enact is law. That's a rule, not a principle. It could also be a broader principle that secures the centrality of Parliament under the UK Constitution. It could be an even broader principle like that justifies central government. So I think the second of these, the idea that it's a principle that secures the centrality of Parliament, we see in a case like Miller 2. That's the way parliamentary sovereignty sounds in that case. I think in a case like Lord Advocate's reference, Scottish case, it's more of a principle that justifies a type of centralisation rather than the role of Parliament. But the point is, the more broadly we draw the principle, the harder it is to argue about what exactly is justiciable. Now, the next section of my talk is going to look at what the principle actually says. And I want to start by ruling out some generalities and then working down to what I think parity of esteem means. Now, again, I have to say this with a little bit more humility than I can usually muster. You know, I am an other. I recognise the depth of the intellectual history of this idea. What I'm not saying is that everybody has to follow my line on parity of esteem. And I know parity of esteem can mean an awful lot of different things. I am proposing a specific legal definition for this that cuts ice in certain sorts of case, and I think those cases are important, and I think courts should recognise this because it will help them to nurture the constitutional settlement in Northern Ireland. So please use it in any way you wish. But I think there's something specific here. Is this a general principle which prohibits discrimination of various sorts, cultural, political, so on? Or is it a specific principle? Well, let's start with the generalities. Here's Mrs. Justice Keegan and McMahon. Parity of esteem comes within the broad principles of equality, fairness, and respect as applied to the two communities. It's artificial to disaggregate parity of esteem as a separate consideration of principle from the overriding objective contained in Article 1.5. The argument there is that this is a make-weight in wider arguments about cultural recognition and discrimination. Might just be verbiage. So rather like the way parliamentary sovereignty is used in Miller, I think there's a sort of high style that we can use when we talk about parity of esteem, but that doesn't necessarily confine it. I want to compare this with Strand 1.5e of the multi-party agreement, What I think is interesting about these two quotes I put on the board is that parity of esteem is set off against that wider principle. The role of the Equality Commission under the multi-party agreement is to monitor the statutory obligation to promote equality of opportunity and parity of esteem. And that can be read both conjunctively and disjunctively. Again, the principles of mutual respect for the identity and ethos of both communities and parity of esteem can also be read disjunctively. And I think that the point of that actually reflects the way in which the treaty came together. Remember, part of the story that Chris told us is this started as an idea about cultural recognition. I think there's cultural recognition early. Later, it is a principle of political recognition. I see you vigorously shaking your head. I would love to hear from you, but in 20 minutes. So I think the difference, at least, between the principles of political and cultural recognition is important. I think part of the argument is that this involves not just recognising communities culturally, it also involves the political aspiration of the community. That's the language of the treaty. Do we need this idea then to be told that people from either community and in either state have equal rights, status and citizenship? Well, no. The whole of the Good Friday Agreement says that. This idea doesn't need to be a lodestar for all of the ideas that we find under the agreement. It should be something specific. We put these words in for a reason. Do we need this idea to know that rights must not be discriminatory in effect? Well, no. The GFA says that, so does the ECHR. And indeed, parity of esteem might in fact qualify the meaning of some of the guarantees in the Convention. We've mentioned the right to march, the issue of parades. Parades are complicated because they're an expression of both the ethos of a community, worthy of esteem, and also an expression of a lack of esteem for another community. The way in which the right to assembly, the right to expression might be understood could be done in light of parity of esteem, compatibly with the Convention. So I don't think parity of esteem ought to be drawn that broadly, because I think one reason why the language of the agreement refers separately to parity of esteem, and in particular refers separately to the political aspiration of each community, is because that idea was supposed to be carried specifically, not just in the general cultural language that you've already seen this morning. Is this then a make-weight in arguments about cultural identity? Well, again, no. I don't think we need this specific idea in order to make sense of arguments about cultural recognition of the sort that Mikkel has mentioned. Is it then a principle of political neutrality, of political recognition? And here there's 2 points, sorry, while I work with the tech. Can it be a principle of mutual veto, as Chris styled it, or is it a principle of political neutrality? Well, I think that's a little more complicated. I need to say a wee bit more about it. But again, my question would be, well, how does that work? And I'll come to that in this next section. So first of all, when we talk about neutrality, what do we mean? The idea of state neutrality is the idea that there's no public ranking of the value of different identities, ethos, or aspirations. And I think a neutral policy in this sense is a policy that ensures all conceptions of the good for a community fare equally well, no matter how unattractive they are. So by this account of neutrality, we shouldn't avoid promoting one community for just non-neutral reasons. We should avoid promoting it at all, even for neutral reasons of efficiency or social harmony. I note that across the island of Ireland, with the exception of the Gaeltacht, the lingua franca is English, even though the official language is Irish for most of the island. I'm not sure neutrality cuts very much ice either in Northern Ireland or in the Republic of Ireland. But it's common, of course, for state constitutions to specify the political commitments they expect of citizens. We have a basic structure in the United Kingdom. Our institutions are supposed to defend parliamentary democracy. I will not speak of this as I'm not an expert on it, but the Irish Constitution is much more specific about the sort of nationalism that it expects of its citizens. And I think that rules out neutrality as a possible interpretation of this principle. But this might be, instead, an expressive principle. What would expressive principle mean? Well, it's a principle of political recognition that requires the governments, but especially the government that's sovereign in Northern Ireland, to recognise the value of the political aspirations of both communities. I'll come on to explain that and how that might work next. And then I'll look at two further problems that we'd have to consider. So this is a principle, I think, that forbids certain sorts of advocacy and possibly certain sorts of discrimination in respect of how Northern Ireland fits into the constitutional framework of the two states. Some aspects of this principle will be justiciable and some won't. And I'll take some examples now. So how would that work? Well, in its white paper, which Tom and I mentioned in our short piece last year, the UK government says we'll never be neutral on this issue. I'm not sure that's obviously compatible with the principle of political recognition that I've just outlined. I recall that Ireland obviously had to amend its constitution precisely to project its neutrality on the issue of Northern Ireland's constitutional status. Now, this particular application of the constitutional principle probably isn't justiciable, but nevertheless, the advice that's going to be given to the minister in the Northern Ireland office will reflect a statement of constitutional principle. The courts aren't the only form of constitutional control that sounds constitutional principles through the UK government. It might affect the conduct of both states in a future referendum. Maybe it does demand a certain sort of neutral advocacy in respect to the constitutional status of Northern Ireland in future political processes. That's important. And again, that's totally separate to the argument that this might be a make-weight in wider arguments about culture. It might also organise legal rules like Section 76. Again, I accept Chris's response to my question earlier. It's unlikely that lawyers in Northern Ireland are going to use this as the framing device through which to make sense of Section 76 of the Northern Ireland Act. Then maybe they should. Maybe this is a good way to understand how some governments discriminate against certain citizens in Northern Ireland. Maybe that form of discrimination under political opinion is better understood as an evocation of the principle of parity of esteem than something else. In particular, it's very far removed from discrimination on the grounds of philosophical belief under the generalities of discrimination law. So that's what I think the principle might mean. I don't think it's a principle of neutrality. I definitely don't think it's a principle that provides veto power. I think it might be an expressive principle that commits both governments to a certain position within political debates about the status of Northern Ireland that might itself ground separate commitments under anti-discrimination law, including Section 76. But what are the problems here? Well, there's two at least. I think these might be separate to the arguments that the others make, that again, Chris very eloquently summarised at the beginning. I'm not arguing that this calcifies Northern Ireland, that it settles the political process. I think there's something slightly different. I think one thing this does is it frames the nature of community in political terms rather than in any of the other four terms that Chris mentioned. I can't remember all: cultural, national, socio-economic, and there was one other. Thank you, religious. When David Trimble described Northern Ireland as a cold house in his Nobel lecture, he did not describe it as a cold house for nationalists, did he? And I think that's a change that's happened over my generation. And here, maybe my Glasgowness comes through a little. The trouble is that this principle, and some of the wider constitutional context of both the agreement and the way it's been implemented through statute, codes Northern Ireland's communities as political communities, not as national communities or religious or cultural or social communities. The shorthand we now use refers to an individual's position on a cultural status of Northern Ireland, not to all of the messier characteristics that loosely define that individual culturally or socially. So, biologically, I suppose, in terms of my ethnicity or family, I come from one of those communities in a way, but that has lots of different consequences culturally, etc. It's messier for that, for me. The thing I want to quote from is Pellin's application for judicial review, where the Lord Chief Justice Carswell says, "We do not consider it's necessary to confine the meaning of the word community in such a rigid way. If it's construed as meaning a group of people in society, in any passage where it's used, the breadth of that group is determined by context. It seems quite impossible to interpret the word community as referring to a wider group." The reason I think that's important is because I'm Scottish, not because I'm from Glasgow. For roughly 20 years now, the Scottish political system has been organised around positioning on a constitutional issue, rather than wider social or cultural issues. Now, our constitutional politics are probably messier than the constitutional politics here. They don't track community as clearly as they might here, but I still see the danger of a principle that amplifies the political nature of that community rather than its cultural characteristics. The second, and I think the final thing I have time to talk to you about, It's what counts as a political aspiration. As I read before, I think the key language that we see introduced in 1998 is it's not just to do with discrimination or valorization of the cultural aspects of one or other community. It's a recognition of the importance of their political aspirations, of the way that they see Northern Ireland developing, what it's going to become. The key to the kneecap case is the difference between that and the cultural characteristics of kneecap. Now, of course, we don't have a reported judgment in that, but I note the concession of the UK government following the change of government last year. But if parity of esteem is a principle of political recognition, then the political aspirations of each community are obviously not static. They don't just have to do with the Union of 1800s or the partition of 1920, but with what some people might say is the partition of 2020. And so that living tree, that moving picture of the way that political aspiration evolves in Northern Ireland, I think is a difficult thing to fix. So it's a principle that I think can have certain positive consequences. I definitely think the neutrality that we expect of both parties in respect of political processes might be a significant aspect of the principle. I think the way in which it undergirds non-discrimination on grounds of political opinion could be important in cases like kneecap. I think that's separate to the way in which it's used culturally in cases like McMahon or Sousa. But it's treacherous in some ways. It's treacherous, first of all, because of the way in which it codes communities politically rather than culturally. I think that's totally separate. And I think it's treacherous because of the evolving nature of political aspiration under the principle. So, just to revise what I've said, I'll come back to the beginning. I started by trying to outline what I think a constitutional principle is. I don't think it's a legal rule. It's not justiciable in the sense that Section 76 of the Northern Ireland Act is justiciable. It does have its origins in international law, but so do lots of other constitutional principles, including, say, the independence of the judiciary. I think it might be justiciable in respect of some cases, but not others. And in particular, the case that I've mentioned, especially in ECAP, would be cases where I think there might be a justiciable application to this idea. But it depends what we mean by constitutional principle, and it depends what the content of that principle is. I ruled out certain ideas about what that content might be. So in particular, I don't think this is a cipher for the whole of the GFA, still less for the whole of the convention. I don't think it's useful to do that. If that's what we mean by parity of esteem, then we rob it of any specific application. Now, that doesn't mean you can't use it in that way, but of course words like discrimination, I mean, when Jane Austen uses that, she means fine taste. Discrimination has a specific legal meaning, and I think parity of esteem does too. I think what parity of esteem adds, both to the existing debate and also to alternative wordings of that treaty, is the addition of political aspiration as a ground on which states ought to be neutral, and in particular, a ground on which they ought not to discriminate. That's largely an expressive principle. It's to do with the way in which the state projects its own values to its citizens, and we see both states manoeuvring around that, particularly around the millennium. But that's also a treacherous principle. It changes the nature of political debate in the doing, and it also forces us to reconsider what we might mean by political aspiration. Thank you very much for listening. I'm sure I will get questions, and I look forward to that. And I look forward to Jane.
Thank you very much, Ewan. I should clarify that when you asked to be put down the list from Chris, you have to remember that I lived in Edinburgh for 6 years, so it's not that I didn't understand your Glasgow accent, it's just that in true Edinburgh fashion, I'd simply ignored it. So now, Dr. Rooney, if you will, please.
Thank you very much for the invitation. The papers so far have been very stimulating, and I hope I can contribute to this wonderful conversation. I'm going to use the case study of abortion reform in Northern Ireland to argue for the parity of esteem of feminist constitutionalism vis-a-vis liberal constitutional thought in Northern Ireland. In the context of education and healthcare, the term parity of esteem is used to facilitate a cultural transformation on what should be included under the purview of education and healthcare. In particular, vocational education should be provided for and recognised as equally as important as academic education. in relation to healthcare, mental illness should be considered just as serious as physical illness. Further, the interrelation between those categories should be discussed, and the support of one category can reinforce and improve the provision of the other. Parity of esteem, in this sense, requires recognition of the symbiotic relationship between the two respective categories. Vocational and academic education provide a collaborative workforce to ensure that services can be delivered to the people. Mental health care and physical health care can be interlinked. Therapy and medical interventions, such as hormone or chemical therapy, can alleviate symptoms associated with mental health, as well as having positive impact on physical well-being. Adopting this understanding of parity of esteem, I examine the extent to which feminist constitutionalism is taken seriously in a mainstream liberal constitutional thought in Northern Ireland. For the purposes of this paper, I define feminist constitutionalism in a narrow sense to mean issues relating to women, an LGBTQ-aware understanding of women and men in this context. I find that women issues are sidelined in dominant constitutional narratives in Northern Ireland, despite the fact that feminist issues have tested our constitution and resonate with other constitutional events and issues taking place at the same time. The feminine is othered, sidelined, exceptionalised, even in a context where Northern Ireland is already relatively exceptionalised in the UK Constitution, a double exception. I argue that if we don't other the feminine, we can learn more about our Constitution and take steps to improve democratic legitimacy in this complex, devolved and island setting. The feminist issue that I take as a starting point is abortion reform in Northern Ireland. The mainstream issue that attracted much attention from public lawyers is the Northern Ireland Protocol. For the purposes of the presentation, I look at the judicial review proceedings in relation to abortion and the protocol. So the Society for Protection of the Unborn Child judicial review proceedings and the Alistair case. In particular, I look at the treatment of the Northern Ireland Act as a constitutional statute versus legislation implementing international law. First, I'll just provide a bit of context on the feminist issue, abortion reform in Northern Ireland. Section 9 of the Northern Ireland Executive Formation Act, the 2019 Act, imposed duties on the Secretary of State for Northern Ireland to make provision for abortion and post-abortion services in Northern Ireland. Under Section 9, the Secretary of State had to ensure that the recommendations of the UN Committee of the Convention on the Elimination of All Discrimination Against Women had to be implemented. Those recommendations included the decriminalisation of abortion and provision of abortion healthcare in particular circumstances, including unconditional provision up to 12 weeks gestation and cases of abortion in fetal abnormality and severe fetal abnormality and grave physical health with no gestational limit. Section 9 required that the Secretary of State must by regulations change the law of Northern Ireland so that it conforms with these recommendations. And litigation ensued challenging the regulations enacted by the Secretary of State under Section 9 of the Act. So there was the 2021 regulation where it was stated that the Secretary of State could direct any minister or the Department of Health to ensure that the relevant services were put in place in Northern Ireland. And the 2022 regulations placed a duty on the Department of Health to make abortion services available as soon as practicable and removed the need for the Executive Committee approval before services could be commissioned and funded. In the judicial review proceedings, a conflict was identified by the complainants between Section 26 of the Northern Ireland Act and the regulations. Section 26 of the Northern Ireland Act, as you probably already know, gives the Secretary of State power to direct action to be taken by a minister or Northern Ireland Department if such action is required in the view of the Secretary of State, to comply with international obligations and other matters relating to security and public order. The complainants argued that the 2021 regulations purported to amend Section 26 of the Northern Ireland Act by implied repeal. And they argued that Section 9 of the Parent Act, the 2019 Act, could not be read as authorising the Secretary of State to bypass the Northern Ireland Act. They argued that the Northern Ireland Act was a constitutional statute and could not be impliedly repealed by Section 9 of the 2019 Act. The High Court, Judge Colton was the judge in this case, understood that the CEDAW recommendations were not international obligations for the purposes of Section 26. I would argue as an international lawyer that this is not a clear-cut issue, and further understanding of the sources of international law could be called into question. But regardless, this argument presented by Spock is that the 2021 regulations amend Section 26 by providing an additional power to the Secretary of State beyond international obligations to include the committee recommendations of CEDAW. Judge Colton found the regulations do not amend Section 26. The regulations provide the Secretary of State with an express additional power to carry out the obligation imposed upon him under Section 9. This is not an international obligation, and it is not the implementation of a report of an international organisation. Despite this finding, he does consider the relationship between the two constitutional statutes, and he does frame them as constitutional statutes. And he draws heavily on his own decision, High Court decision of Alistair, to discuss constitutional statutes, including relying on the principle of parliamentary sovereignty, but also recognising the Thoburn criteria of constitutional statutes. And as you know, in relation to Thoburn, a constitutional statute exists where the right at issue is constitutional or fundamental, and in that context, a hierarchy should be created between ordinary and constitutional statutes. And also it modifies the relationship between the citizen and the state in some way. Colton stated that when enacting the 2019 Act, Parliament was providing for the Secretary of State to act in a devolved area, which speaks to its constitutional nature, and was intervening in a human rights context, as its subject matter is the human rights of women. And in the words of Thoburn, Lord Laws in Thoburn, enlarges or diminishes the scope of fundamental rights. I would disagree that the 2019 Act was specifically providing for the Secretary of State to act in a devolved area because of the status of human rights within the devolution framework that cannot neatly fit into a devolved or reserved competence, but rather sits in a different position in the devolution framework in Northern Ireland. But I would agree with the constitutional nature of the Section 9 of the 2019 Act. And it is really significant that Judge Colton gives constitutional recognition to Section 9. And in other jurisdictions, abortion reform of this scale would be considered as a significant constitutional reform, but has been not so acknowledged in Northern Ireland. In terms of the Court of Appeal decision, Justice Kagan took a much more orthodox point of view, and she said merely the principle of parliamentary sovereignty was in operation. 2019 Act was a later act, and in relation to the extent to which it diverges from Section 26, it takes priority in this specific circumstance. But she also said that Section 9 only gave the Secretary of State for Northern Ireland to intervene in transferred matters, and she actually bypassed the international obligations question. She said that abortion reform was a transferred matter relating to health, and really took advantage of parliamentary privilege in ignoring the fact that human rights was at the centre of justifying Westminster intervention in relation to abortion. The Brexit issue, there's one last thing I want to mention in relation to that, and that's that Justice Kagan states that we do not need to consider the discourse on the issue of constitutional statutes. There is no modification or amendment of the Northern Ireland Act. The constitutional statute arguments are of academic interest only. So turning to Alistair, the Brexit issue concerns the lawfulness of the Protocol on Ireland, Northern Ireland. It forms part of the Withdrawal Agreement, an international treaty between the UK and the EU, and the UK is no longer part of the EU's single market and customs union. The protocol ensures that no checks or controls apply to goods moving between Ireland and Northern Ireland in either direction, but checks do take place on goods entering Northern Ireland from the rest of the UK and other third countries. The issue that arose was whether the protocol conflicted with the Acts of Union. The protocol was given effect in domestic law through Section 7A of the 2018 European Union Withdrawal Act, and it provided for the disapplication of conflicting domestic legislation. Article 6 of the Acts of Union provide that subjects of Great Britain and Ireland shall be on the same footing with respect to trade, and the protocol requires the payment of a tariff in respect of goods coming from Great Britain into Northern Ireland, and then therefore the argument is that this conflicts with placing subjects of Great Britain and Ireland on an equal footing in relation to tariffs. And one challenge that arose was this issue regarding constitutional statutes. In the High Court, Judge Colton stated that there was a conflict and applied the Thoburn criteria. And he stated that in this context, Section 7A of the 2018 Act overrides the Act of Union. Justice Kagan applied the orthodox theory of parliamentary sovereignty, but also states that the 2018 Act is a modern statute which utilises clear language to achieve its purpose, which is essentially the subjugation of any other domestic legislation prior to this Act that might be in conflict. And the Supreme Court mirrors the language of Kagan, but muddies the water because it hints at EU law having exceptional status in UK law and being an exception to the dualist nature of UK law, but then proceeds to talk about dualism and domestic statutes. And even though the Supreme Court endorses simply the parliamentary sovereignty, it does discuss different languages relating to conflicts between earlier and later statutes of variable significance, overriding, modification, subjugation, suspension. So the issue is not fully clear or settled by the Supreme Court. However, it sort of concludes its judgment by saying that the issue regarding constitutional statutes is merely academic. And it adds that the interpretive presumption that Parliament does not intend to violate fundamental rights cannot override the clearly expressed will of Parliament. So that is a sort of disappointing statement to make relating to devolution and parliamentary sovereignty and fundamental human rights. So in both cases, in my opinion, the outcomes are good, but the statements made regarding constitutionalism in the UK and Northern Ireland context are wanting. If we look at the Spuck decision, the abortion decision and Alistair together, rather than just Alistair, we can see deeper underlying constitutional issues at play. A more principled approach that provided further respect to the devolution framework and was able to grapple with the legal and political reality of the implementation of international law would be better for the democratic legitimacy of these significant constitutional events. Measures taken by the UK Government and Parliament to ensure compliance with international law in Northern Ireland have exposed deficiencies in the constitutional and devolution framework. The two issues presented are different, but are linked by the implementation of international obligations. These cases taken together provide a reading of the relationship between parliamentary sovereignty and the devolution framework that is scared to grapple with international law. It could be to do with dualism, it could be to do with expertise, it could be to do with the politically polarising nature of the decisions, and crucially the fact that these issues cannot be separated into a devolved or reserved matter. Judge Colton and some feminists recognise Section 9 as a significant constitutional moment, and this would be the case in any other jurisdiction. Abortion reform in Northern Ireland was punk. There was an instrumentalisation of the vagueness of the Northern Ireland Act and its treatment of international obligations in order to persuade Westminster that it had competence to legislate on the matter, even beyond reformation of the Executive and Assembly. What I term a guerrilla constitutional reform. There is a sense of we got away with it. Why bring up all of the constitutional questions that remain unanswered? But wouldn't it be good if we stood behind Judge Colton, who recognised the constitutional nature of Section 9, and we could celebrate the feminist constitutional moment, and were able to provide a principled feminist justification for the sweeping powers of the Secretary of State? It would also be good to highlight the grave and serious nature of the rights violations taking place in Northern Ireland prior to the legislation, recognised as cruel and inhumane treatment by the UN Covenant on Civil and Political Rights, as well as the Women's Treaty, CEDAW, and treatment that would be considered contrary to the inter-American and African human rights system. And elsewhere, I unpick some of these issues in relation to international human rights law and the capacity of international human rights law to contribute to democratic legitimacy in a devolved setting. There is more work to be done, but the take-home point for this presentation is that some feminists want to be part of making constitutional law in Northern Ireland, and public lawyers can help this along by considering further the constitutional implications of cases like Spock, beside other constitutional issues, even Brexit.
Okay, we can turn it over to the floor, but I'm just going to abuse my chair's privilege for a moment just to draw out something that struck me. You, in your presentation, spoke about Parity of Esteem as a principle of cultural recognition. And we've been speaking about this as cultural recognition of the two communities, but there's more than one way to slice a cake. And we sliced the Northern Ireland cake into the communities of Unionists and Nationalists, but there is, of course, the slicing of the cake into male and female. And I think it's interesting looking back at the 1990s experience, the way in which people like Monica Williams, the Women's Coalition, played into these discussions, but perhaps it doesn't come out in the text, or certainly in the way in which the text has been received and dealt with. I suppose that wasn't a question, that was a statement. But does anyone have an actual question? We've got the gentleman at the back there. And also Mikkel. And Leah and Colin.
It's a question for Ewan. Parity of Esteem can be seen as providing an open space. It's kind of the idea that, you know, we're sharing this space, we're sharing the idea of open discussion. And therefore, the phrase must be a kind of a way of diluting and diminishing and destroying all forms of discrimination. Is that the kind of principle in which you were kind of trying to explain that discrimination must be eradicated, and it must be eradicated through that process?
Thank you very much. I think that's a laudable principle, and it's very important that that principle is in the central part of the Constitution here. But no, that's not what I think parity of esteem means, because I think it would duplicate other things if we made that the meaning of parity of esteem. I don't even think it means cultural recognition, because again, I think that would duplicate things we already have. I think the sort of discrimination that parity of esteem bites on is discrimination according to your aspiration for what Northern Ireland is and what it's going to become. I think that's a very particular sort of discrimination, but it's really important And I think the best use of that principle would be as an evocation of that idea rather than the generality of discrimination as a whole. But I say that not because I don't think discrimination is important. It's hugely important. We need other ideas that lift that weight. It's just maybe this isn't the idea that should be carrying it.
I think Mikhail was next.
Thank you very much both for your interesting talks. First to Iwan, you are like coming up with a really interesting concept that I'm trying to think about. It is the concept of political community, right? That it is central in our political system. You say, and I agree with you, that the political community, it is not exactly the same as national community or cultural community. But then what is it composed of? What is it a political community? Which people are political community? Especially for the purpose of considering who has authority, who has constitutional authority. Finally, who is the constituent power? Yeah? Because I think that according to our construction of the modern state, it is political community based on a nation, at the same time based on a cultural, let's say, ethnicity, in simple terms. No? So then how do you reconfigure that? What is it, the political community? And I think that's key in our debates. And for Jane, thank you very much for the legal issues around feminism and abortion. I would like to ask you something related to that, but a bit separated from that. How do you think that feminist movement, and LGTB is kind of contributing to permeate, to cross the lines between the different national or like cultural or communities in Northern Ireland, if any? Thank you.
Thank you very much, Mikhail, for your question. So I think that in relation to Northern Ireland and feminist issues, and you mentioned the LGBTQ community as well. So I think that really feminists have taken advantage, I think, of, as I said in my presentation, more guerrilla warfare type strategies. It does utilise the court, the different levels of governance, of political governance, lobbying MLAs and MPs at both the Northern Ireland Assembly and the Westminster Parliament, and other different organisations associated with the state, like the national human rights institutions. The Northern Ireland Human Rights Commission was really instrumental in galvanising the legal and political system, the state system for reform. But I do think feminists in the Northern Ireland context see that as I say, playing with the state rather than the state actively being able to encompass their concerns as constitutional subjects. And I think that what you were talking about, constituent power, and a feminist constituent power. And in order for that to exist, I think the way that the constitutional arrangement is set up in the Northern Ireland context would need to maybe concretise particular procedures for women to be further involved. Obviously, representation in the courts and the government has improved, representation of women, and that's excellent. Justice Keegan is a really excellent judge. But I do think that it was more of the guerrilla warfare that facilitated feminist reform rather than the Northern Ireland Constitution facilitating the feminist constituent power.
And just in response to the first part, I think I have to be specific about the thing that Parity of Esteem is supposed to forbid the state to do. it's essential to the structure both of the Good Friday Agreement and also Parity of Esteem that the UK remains a union and Ireland remains a republic. You don't have a political aspiration without those things. So what I'm not saying is that the United Kingdom should cease to be a union, support a union, etc., because of the principle of Parity of Esteem. The question is what the United Kingdom says about how Northern Ireland fits into that picture, and likewise what the government of the Republic of Ireland says about how Northern Ireland fits into that picture. I think the principle requires the state to be neutral about that question, which is separate to the question, I think, of political community. And of course, I mean, there are a much wider set of obligations that reflect both the ethos or the identity of political communities beyond this specific thing that I'm concerned with. If, you will know more about this than me, if the government commits to the redevelopment of Casement Park and offers more money, that's potentially a parity of esteem issue. It has to do with the positioning of the government in respect of one or other community. That's why people argue about it. I don't think this constitutional principle needs to bite on something that big. I think it's narrower and, in my view, therefore more targeted and more important than that.
Okay. Chris has a hand up, but I think Leah and Colin first.
Thank you so much, both, for your presentations. I have a question for both of you, and it's the same question. So when we speak of principle, and sort of implicitly, I've heard this in both your presentations and also in how you just answered the questions. Principle, it might require something. So it is action guiding, at least in some sense. We don't have to agree in what sense, that's fine. But it requires that things be done or not be done, right? Or things to be taken into consideration. And so far, I think we've mostly been hearing about and arguing about what it might require is done, what not be done. And my question is about steps before that. Who is the addressee in your view? Is it just public authorities? Is it mainly public authorities? Who might be a public authority? Is it communities, individuals? Why, right? So if you could make that explicit, and I don't know. I'm asking, right? So who is the addressee, and to what extent is it action guiding? So why is it a principle and not something else? So the sort of the first part of that. Thank you.
I'll take it first. The language of the agreement, again, others may be able to correct me, but I think it is the authority that is sovereign in Northern Ireland. So it doesn't just address itself to the government of the United Kingdom, it addresses itself to any future government that remains sovereign in Northern Ireland. And one of the reasons why it's important is because it shapes the way in which you would be able to build a nation under different political circumstances. So I think it has to be that. I think that's correct. And the principle I have in my mind is a principle of expressive neutrality with respect to that ongoing authority. Is it action guiding? Well, yes, it is. I think I've suggested some cases from whether you can refuse to give a BPI grants and people who claim to be nationalists to whether you ought to be campaigning for the union in some future Section 1.1 referendum, where this principle would bite on the duty that you would hold. Not all of that action is justiciable. I agree. Some of it is. And I think even if it's not justiciable, there would still be constitutional consequences within, certainly I'm thinking of the UK government because of the structure right now, in respect to that principle. You'd still have advice there. So I do think it's action guiding both at the large and small level.
Thank you, Leah. For me, the principle is a little bit more abstract and the audience is a bit wider. And that's why I related to sort of the literature on education and health, because I think it is, as I said, sort of more of a cultural transformation in those contexts. And that was what resonated with me in relation to feminist constitutional literature and more liberal constitutional thought. So I suppose my main audience is the liberal constitutional lawyer that would not self-identify as a feminist or might think they're a feminist, but it doesn't engage with the feminist constitutional literature. And obviously I use Spock and Alistair as cases for sort of just looking at the relative attention that each one got in relation to constitutional issues. but it's something that I've seen prevalent in some of the more critical literature as well. So, for example, recent anthologies on material constitutionalism, which resonates with a lot of ideas that the feminists put forward, but don't acknowledge them. In fact, just treat as peripheral, as social identity related constitutional changes. So, not real constitutional changes, just identity politics. And then also the Marxists, sadly, even though there's so many crossovers between Marxism and feminism as well. And I suppose maybe I was patronising my audience with Northern Ireland constitutional law cases, because I knew that it might be catnip for public lawyers, but I've obviously underestimated everybody here. It's a much more open discussion. And I know it's catnip for Colin, who looks like I know that he probably disagrees with a lot of my doctrinal interpretations of those cases. But so that's really who my audience is. And I'm taking this Parity of Esteem conference as an opportunity again to further the feminist constituent power.
It was catnip for me as a public lawyer as well. Particularly, I knew that in the Supreme Court in Alistair, the Supreme Court had referred to the debate over constitutional statutes as being merely academic, and using the word academic in like a pejorative sense, meaning meaningless. That kind of raised my hackles. I suppose that's just a professional deformation. But I hadn't realised that it was the same in Spock as well.
Yeah.
Which I think then, okay, if we take parity of esteem as not just a constitutional principle, but as a kind of a principle of civic virtue, a principle of respect, then it can filter down into professional contexts. Parity of esteem between the judicial and the academic, parity of esteem between the liberal and the Marxist and the feminist and constitutionalism. Am I right in...
Yeah, that's 100%.
Well, gold star for me then. So I think, Colin, you might be up next, and then we've got Chris, and then we've got Colin as well.
Well, hopefully it's catnip for everyone to talk about the most exciting economic/constitutional zone the world has ever known. I'd like to drill down a little bit more, Ewan, when you're looking at your conception of parity of esteem, and to try to put it in that range of concepts that are covered by paragraph 1, Roman 5 of the UK-Ireland part of the agreement. Because I'm struggling to get the difference between your conception of parity of esteem and what rigorous impartiality is doing, and whether you think they are doing different things. And I note when you talk about the conception of a citizen within Ireland as a state, you say, well, that couldn't fit within an idea of parity of esteem as it is at the moment, but it doesn't have to, because it's not the state with statehood over NI. And whether those questions would have to change if Ireland was the state with statehood over this territory, that's almost beside the point here, because we're dealing with what these concepts mean at the moment, and in particular in the state with statehood. So I really want to get what the difference is, and potentially to look at the relationship almost on the other side between parity of esteem and equality concepts, because there's a lot that parity of esteem is perhaps was particularly doing in the Brexit debate, that could never have fitted within Section 75 or generated a litigable equality right. So it seems that parity of esteem, I would love to get more of your handle on that relationship between it and those other elements of the supposed constitutional principles of binding the state with statehood over NI. And Jane, I wonder if we're taking this idea that parity of esteem didn't have a purchase within the concept of feminist constitutionalism. Did some of the other concepts coming out of the agreement actually fill in that gap? The whole idea of the North is next was predicated upon the fact that after the abortion referendum in Ireland, NI had become such an outlier by comparison to the other jurisdictions in the archipelago as to be utterly anomalous and to force this issue to the top of the agenda. Now, you could say that that's an issue of guerrilla constitutionalism, but there was emphatically within that an idea of rights equivalence. And I think you could say that drives, well, quite clearly upon some of the language of the 1998 agreement. I don't think it is entirely divorced, even if it is divorced from a concept like parity of esteem. And I wondered what your thinking is, why the thinking is that feminist constitutionalism is entirely divorced and isn't drawing upon the language of the 1998 agreement, that it might have been taken from your paper.
If that's all right. I don't think I was implying that the Good Friday Agreement completely eschews feminist constitutionalism. And of course, there is the principle of equivalence. And usually we refer to it in the circumstance of Northern Ireland having, well, we've seen it obviously in Article 2 of the protocol. But that's that I wasn't inferring that, and I also don't think that the North is next. The fact that so obviously the Republic of Ireland legalising abortion under much more restrictive circumstances than in the North. It was a political propeller for reform in Westminster, but it certainly wasn't part, and I'm going to breach parliamentary privilege here, but of the Hansard debates, or it was a very minimal part of that. And more what was drawn upon was the ability of Westminster to legislate in this circumstance according to international law rules, which are very clear. Vienna Convention on the Law of the Treaty says that it's ultimately the responsibility of the UK to comply with its international obligations. And the UK Supreme Court said over their dicta that there was a breach of the Human Rights Act in relation to Article 8, fatal fetal abnormality and sexual violence, and also that it was a human rights issue, which meant that in relation to the devolution framework, it didn't fall squarely within a transferred matter, despite the fact that it also covered health and criminal law issues. So I think that in relation to the Northern Ireland constitutional framework, I've neglected in that presentation to talk about its relationship with the Republic of Ireland, which is extraordinarily significant. And I certainly, moving forward, I will take it as a point, the principle of equivalence, but I don't think it was in a huge factor in the way that the constitutional order in Northern Ireland operated in relation to abortion. It was not, it was very peripheral in terms of constitutional political decision making. And I think the Good Friday Agreement obviously contains wording to the effect that against anti-discrimination, including women, but that I think that the sort of treatment by possibly the constitutional law academic community does still make peripheral these feminist issues, and in particular abortion. And I think it's important that all constitutional lawyers talk about the abortion case law if it does have something significant to expose about the constitutional arrangement here. I don't know if that answers your question. Okay, yeah, that's lovely. Thank you.
Colin, your question. There's a question of textual interpretation here that sits inside a question of politics in the Constitution, and they're connected. The textual question, if I understand it correctly, is, are these conjunctive or disjunctive? Is parity of esteem something separate to ethos, identity, or is it something that is connected inseparably with those things? And it'd start with that. And I think that question is connected to whether, principally, this is a question of cultural recognition or whether it's a question of both cultural and political recognition. And I know that that was a point in my presentation where not just Chris, but a few people seem not to agree with me. So, I mean, I open this up. My knowledge of this topic is somewhere north of Secretary of State Karen Bradley, but probably south of the media in this room. So this is an area where I might be wrong, but I don't think I am, and I'll explain why I don't think I am. My understanding of the way that that debate evolved, noting what Chris said about the Coleraine speech at Mayhew, etc., is that for a long time before political recognition was on the table, it would have been possible to have some sort of agreement that each community recognises each other culturally. What Chris referred to as false equivalence, if I've understood correctly, is the argument that cultural recognition and political recognition are two different kinds of recognition. And the idea that the union is something, so Chris, again, I see you shaking your head. Would you like to go, or shall I outline the way I understand it? Okay. My understanding of that is that you cannot make the dissolution of a state as a political objective that you advocate equivalent to the recognition of another culture. That was the way I understood that point on false equivalence. It's an argument that political recognition involves a much greater gesture than cultural recognition. And my understanding, again, historically, and I haven't been back to the TP, is that that's sequenced, that there's a period in which cultural recognition is possible, and then it's only through the evolution of the debate through the mid to late 1990s that political recognition becomes a possibility. What I mean to say is, I would have been astonished if you could have had a treaty in 1991 that says there should be rigorous impartiality with respect to the political aspiration of the communities. I don't think anyone would have agreed to that because it would have meant something very different. I think the inclusion of those words is significant, and the reason why we should read them disjunctively is because of that evolution in the argument from cultural to political recognition. Now, I'm sure there are all sorts of misconceptions in the way that I've set that out, but to me that's pretty clear, and I cannot see any way around that idea that it would have been impossible to include those words in 1990, 1991. That's why I think they ought to be read disjunctively, so it's a textual argument inside a constitutional argument.
Hi. Both papers are wonderfully rich. Thank you very much for both of them. Lots and lots to discuss. I hope we get a chance to talk about all the issues over the next today and tomorrow. So let me just pick up a couple of points. I won't try to be exhaustive. And certainly I hope not to exhaust the audience as well. So yeah, just two points. One is on the question of cultural and political at issue. The point I was trying to make, I obviously didn't make it clearly enough, was that the parity of esteem language, at least in terms of how it was used in the context of the Brooke-Mayhew talks, that's from 1990 to 1993, roughly, was in the context of political recognition, wasn't in the context of cultural recognition. Cultural recognition comes in afterwards. It's the other way around from the way you're describing it. And it's not true to say that there wasn't the possibility of an agreement on political recognition prior to Good Friday Agreement, because it had already been recognized by the two governments in the Anglo-Irish Agreement of whatever it is, 1988, 85, thank you very much. I was in the States at the time, so my memory of all this is very weak. But it was in that. Parity of esteem language is not used, that's the development. But in terms of the notion of some degree of equivalence politically in terms of the recognition and aspirations, that was in the Anglo-Irish Agreement. So I disagree with your sequencing. That's why I was shaking my head. My apologies. It was rude of me to do that. More generally, if I could just sort of test your argument in this respect, and thank you for engaging with mine so generously. I'm very grateful. Is to test it in the following way. Let's imagine there is a referendum on unification. So let's imagine that the Secretary of State calls such a referendum. Personally, I think it's unlikely in the near future, but let's assume it. There's a campaign. And in the context of that campaign, the British government is debating in the cabinet what position it should take. So what do you say it should do? So various different options. It could just not say anything as a government and simply leave it to political parties. Yeah, so the Conservative Party campaigns, Labour campaigns, or whatever, but not the government. So it could do that. That's a kind of neutrality position from the government's point of view. Or it could decide it's going to support one side rather than the other. So politically, it would clearly be under pressure, certainly in terms of the current politics in the UK or in GB or in England, to support the union. Yeah, so a Labour government that decided not to support the union would get absolutely slaughtered in the red tops. So it could do that. Or it could fund both sides. Right, so like in the South, in referendums, they're supposed to effectively to support two sides. And that leads to somewhat complicated, not to say anodyne, leaflets on both sides of particular arguments. None of these options are particularly good. Do you have a different option, or which option do you choose? Right, so that's my first point. Jane, so thank you again for your paper. So this is really not a question about constitutional feminism or feminist constitutionalism. So let's leave that to one side for the moment. Quite happy to engage in that, and that seems a worthy enterprise to engage in. And there's lots of stuff we both know about it. I'm more concerned about your understanding of what was going on in the two cases. And I'm kind of puzzled about that, because I suppose the first point I'd want to make is that we need to be careful about labeling things as constitutional issues when we don't need to. Particularly given the uncertain nature of constitutionalism in the UK, labeling something as constitutional is more a play for a political status than it is for a legal status. So in the Alistair case, it was quite clear that counsel in the case, Mr. Larkin, entirely because he was instructed, and I'm sure not in terms of his own political position, which I don't know, but assuming he was instructed to do it, basically wanted to use a constitutional argument in order to elevate what was otherwise a pathetic argument. Let's be crude about it. And so what the Supreme Court did in the Alistair case was basically to say, this isn't a constitutional question. What is it about parliamentary sovereignty you don't understand? This is constitutional law 101. And you've just got it wrong, so go away. It was a brutal judgment, and quite rightly so. So elevating it to a big constitutional argument gave it a status that it should not have had. On the second point about the Spuck case, and I have to declare an interest that I was involved as counsel for the for the Equality Commission intervening. So we were neutral on the issue. But we intervened on the Article 2 protocol point, as you well know. But your description of the case was quite interesting. And by the way, I mentioned that simply to declare an interest, not to claim any degree of extra legitimacy for the point I'm going to make. But it's interesting that the way you described the case, because the part of the case you didn't describe was the Article 2 protocol point. And in that context, both the High Court and the Court of Appeal went out of their way to make extraordinarily important constitutional declarations, with regard to the status of the protocol, with regard to the limits, effectively, on parliamentary sovereignty. That was the big constitutional decision in the case. Yep. From that point of view, that was an enforcement of international law. It was a recognition that the withdrawal agreement and the protocol had elevated international law in the context of European law, but for British purposes, international law now gave it a status which was extremely important and which has now led, in other cases, to considerably enhanced human rights protections, including in the cases dealing with the Migration Act, which, as you will well know, because you follow these things, in one of the most interesting feminist blogs produced by one of my colleagues here, and indeed, I think, written by Colin, Mr. Justice Humphreys was described as producing a feminist judgment. Now, in that context, that all derives from Spuck, the fact that he was able to do that. So I want to challenge your idea that there is a weak constitutionalism. I want to challenge your idea that it wasn't reflected in Spuck case, it was. And I want to challenge your view that there is, in general, an unwillingness to take a human rights, including a feminist approach, rather surprisingly, I have to say, in the Northern Ireland courts at the moment. I think the opposite is true in all of those instances.
I'm sure that you and I are both chomping at the bit to respond. I feel like I'm back in an Oxford tutorial with Chris. He doesn't remember me, but I remember him from 20 years ago. Well, now I'm going to school you, Chris. No, I think that in terms of constitutionalism and whether it's important or not to call something constitutional, from a feminist constitutional perspective, it is. It's part of that methodology, as you probably well know. So I think that including, for example, a right to an abortion in a constitution has been hailed as a really positive development for the feminist constituent power in places like Colombia and Mexico and all of these different places. And similarly, when abortion is rescinded on particular grounds, it's considered of constitutional significance, and it does resonate with women for their issues to be identified as having the status of constitutional. In relation to Alistair, you're completely correct in relation to the Larkin's argument regarding constitutional statutes and regarding the Act of Union. And as I said, it was a great outcome, like a sort of obvious outcome. And I suppose I took issue with the fact that it was just related to parliamentary, the orthodox point of parliamentary sovereignty, and that there wasn't further recognition that there are some statutes that are hierarchically superior to other statutes. And I think perhaps it goes to the issue of constitutional statutes and just the discourse around that, which attracted so much attention from public lawyers in the context of Alistair, and not Spuck, despite the fact that Keegan made fairly exact points of principle across Spuck and Alistair, and it wasn't picked up in the discourse. And I mean in the constitutional literature. So and the thing is as well, I have to admit that I wrote an article about this, comparing Spuck and Alistair, for a special issue for the Northern Ireland Legal Quarterly that I was editor for, and it was rejected. It was rejected, review and resubmit by one person and outright rejection by another person. So, I definitely need to clarify my arguments here, but what I'm trying to say is that the Spuck case, which you had, you made excellent contributions to in relation to Article 2 of the protocol. And it's, wonderful that you've expended so much energy and labour on it, feminist ally. And also I take your point about their treatment of international law in that respect. And that is something I have to return to. I have a 17-month-old baby. So I just was like, oh, I'm just going to leave Article 2 protocol. I'm going to just focus on Section 26. But I will definitely take that on board. And I think you're completely correct. I mean, there's so many different weaknesses to my argument, but I do think the underpinning one is still there. And yeah, I hope that that responds adequately to your excellent comments. Thank you.
Chris, thank you for being so generous. I have an answer to your second question, and I suppose a question. There are some policies in which you should allow yourself to be dictated by the red tops, and governments do that all the time. I think something like the way that you conduct a campaign in a referendum with regard to the constitutional status of Northern Ireland is an issue in which you'd have to be a bit braver than that. The red tops hate the Good Friday Agreement. They hated it back then, they hate it now. I think that's an issue where you need to hold the line against that kind of short-term politicking. What are the consequences then? So I think, well, let's imagine it's not just the British government, it's the Irish government as well. What I said to Mikel, I think, is still true. There's kind of two steps here. None of this works unless Britain is a union and Ireland is a republic. So the UK has to stand up for the union. So, go on.
The status of the British government and the status of the Irish government is different in this context. I mean, fundamentally different, because you rightly pointed out that parity of esteem, rigorous impartiality, all that applies to the then governing authority in Northern Ireland. The Republic of Ireland would not at that point be the governing authority in Northern Ireland, and therefore it doesn't apply.
I'm not gainsaying that. I'm not saying the Irish government is bound by parity of esteem to behave in a particular way. I'm speculating as to the way that those two governments would have to conduct themselves in a referendum. I think Ireland has to be able to say Northern Ireland would be welcome to rejoin the Republic. And that's not granted. There might be international obligations in respect to that, but you're right, the principle of parity of esteem doesn't bite on that. Likewise, the reason I use this as the first step is the flip side of that is the UK government has to be able to say Northern Ireland's welcome in the Union. Unless it is, then why conduct a referendum campaign? I think the UK government has to be able to retain its unionism while not, as I say, taking the second or the third of the two options that you suggest. I think that's the best outcome that you can have in that situation. I think it's what the agreement requires.
I'm allowed. And the implication of that, thank you for that, and not a surprising answer. Politically, I think that's right. I mean, right in the sense that that's what's likely to happen. The problem is that the principle that then supports that position is one which essentially is the same as that which was set out in the Safeguarding the Union, which is, if the Irish government supports republicanism or nationalism, then the British government should support continuation with the Union. It seems to me directly parallel and to be essentially undermining, therefore, the principle that you sought to establish in terms of parity of esteem.
I don't think those are the same thing. I think saying we're a union, but whether you want to be part of this union is up to you, is different to saying we're a union and you ought to be part of this union. I think those are two different things. I think in respect to the Republic, saying we're a republic and you may join, and we're a republic and you may not join, are different. So I'm not suggesting the UK government has to commit itself to Northern Ireland's constitutional status. I'm saying it has to, at the very minimum, be willing to accept Northern Ireland within the Union, but that leaves open the question of the determination of the status to the people of Northern Ireland, I think. Now, just in your first question, thank you. I need to go back to the Anglo-Irish Agreement. I still have lots of other questions, which I hope I can follow up. My understanding was it's not to do with the relationship between the UK and the Irish government. It's to do with the multi-party issue. So I had thought unionists, particularly under this principle of false equivalence, were opposed to the sort of political recognition that was being discussed at government level much later, and would therefore find it much harder to sign an agreement later than you're suggesting. But again, that's something I need to read more about rather than something that I'm certain about. I'll follow up. But thank you. That's educated me.
Well, thanks, everyone. I think we've got time for one more. And Colm, I remember seeing your hand up.
It's such an interesting conversation. I'm not sure my question will add to the gaiety of nations. Well, actually, it's two questions, and they're slightly hypothetical and left field. So feel free to ignore me and come back to me in the coffee break or next week if you want. Ewan, just to sort of crystallise the line you're trying to draw between, disengagement from interfering with constitutional traditions and still manifesting a commitment to the Union. If the British government, in the context of a more or less imminent unification referendum, turns around and says, oh, incidentally, if you vote for independence, we're cutting off all financial support to Northern Ireland, with the exception of outstanding pension liabilities, from 2 years after a vote for unification. Good luck. Well done. See you later, no more cash. That potentially could have quite an impact on a unification referendum. On your approach, would that be a breach by the British government of some sort of commitment to parity of esteem and rigorous impartiality and that nexus of principles? Or would that be just a manifestation of its overarching commitment to the Union? In other words, I'm just throwing that in as a hypothetical scenario to see how that would map out. And feel free to come back to me on that. Jane, I think your paper is absolutely fascinating, and I've been trying to get my head around it. What would you say to someone who came to you, perhaps with a research fellowship in the Judicial Power Project or something, and were to cheerfully say to you, 5 years ago we were all on board formally with liberal feminism and international human rights law. Now we've won a lot of arguments in certain quarters, and now that's all much more contested, and all of this is now political commitments, it's contested, and so on. So given the contested nature of feminism, human rights feminism as reflected in international law, this cannot be constitutionalized now that we've made our objections loud enough for it to become politicized. Therefore, what you're advocating is something that might have worked 5-6 years ago, but now is no longer sufficiently settled to warrant constitutionalization. Just curious as to what your response would be to that critique. Again, feel free to come back to me.
Colm, on your first question, I think this is a really interesting question. There's actually a bit of the paper I didn't get to lecture that's about this. So in the last two papers, the one at the workshop and the one that we did together, there's a sort of weasel paragraph that says this might have quite complicated connections to wider theories of political liberalism, and we can't explore that now. I think there are at least 3 ways in which we can stratify this. Is this a principle that's to do with state neutrality? Is it to do with the exclusion of ideals? Is it the principle of benign neglect? I didn't do that triptych in the paper, but I was able to go into reasons why I don't think it's to do with state neutrality. I talked about, for example, the use of the English language, the Irish language in Ireland. I don't think the government is committed in that way. I think the expressive principle I talk about is a principle of the exclusion of ideals, that the government isn't supposed to say we think it's better that everybody here is British. That's flatly inconsistent with lots of other aspects of the Good Friday Agreement, but I think that's one aspect of this expressive duty. Is it benign neglect? So are you supposed to just avoid these questions? Well, I think it might be possible to make a decision that, for reasons totally unconnected to the political aspirations of the people of Northern Ireland, had an impact upon the political aspirations of the communities. Brexit being the obvious one. Very deeply connected to the political aspirations of the communities, but not pursued in order to achieve that ideal. So I think that, there's a bit more to say on that question, but I hope you can see kind of some of those wider debates, not just about multiculturalism, but about political liberalism, give you a way in which you can develop the content of that expressive duty, but I just couldn't do it in 20 minutes, that's all.
Jane, last word.
Yeah, thank you, Colin. And I think just to clarify in terms of the contestation that you're talking about, in terms of legalisation of abortion in Northern Ireland, for example, in those extreme circumstances like fatal fetal anomaly and sexual violence, that's all legislated for. And now I think you're trying to say that it's just much more difficult in the UK context, even around abortion. Is that what you're talking about, like in telemedicine and even pregnant men and things like that?
Thank you, Anne. Ewan, he beat you to it.
Colin to column interaction. No, I just meant in general, a sort of an overarching challenge to the way you're treating sort of human rights feminism, so to speak, as something that should be recognised, if you want, as underpinning constitutional values. Though we should be treating this as something that we respect, whereas others might say, well, actually, no, this is something we're still arguing about. So we don't get to treat that as a value basis.
Okay, yes, of course. Well, I think maybe it had a moment, is that what maybe you're saying? And then, but I think there's so much work obviously to be done, and that human rights as a vehicle, the purchase of human rights in general has fallen, hasn't it? The purchase of human rights under the European Convention on Human Rights and the Human Rights Act has fallen. And we have to use as many different tools to further a feminist constitutionalism. And in the context of the Northern Ireland Constitution, human rights were instrumentalised, or through human rights litigation and lobbying at Westminster to further the feminist agenda. But for sure, it is human rights feminism is a very peripheral part of a feminist constitutionalism. Not peripheral, that's unfair, sorry. But we sometimes underestimate the role of international human rights law in furthering a feminist constitutionalism. And I suppose whenever I say that, I am responding to the critical feminist legal scholars. And maybe that's who you're talking about as well. There's many more instruments, many more effective ones. Human rights can actually limit the feminist agenda. Certainly the European Convention on Human Rights does nothing to further reproductive rights. It's a very limiting and debilitating instrument for the feminist agenda in the UK context. But I do think we have to use all of the different tools at our disposal to fulfill a feminist demand. And I had a very narrow interpretation of a feminist constitutionalism, issues relating to women. But a feminist methodology can benefit everybody. And as I say, it has cross sections with materialism, Marxism. Money has an awful lot to do with what the reality of the Constitution and women's experiences have something to say about that. So I hope that answers your question, Colin. I was equally intimidated, Colin has never formally taught me, but I always encounter him at these events, and you always ask very pertinent questions, so thank you.
Well, thank you so much, Jane. Thank you so much, Ewan, and thank you all for listening and for your questions.